a matter of seconds.
Hey everybody, give us just a few minutes. We're having a few technical difficulties here. So I'm Yvonne Brannon. Welcome to our webinar tonight. And just give us a second here to get Justice Earls on as a panelist. Oh, there. Welcome, Justice Earls. We're so glad you're here. Sorry, we sent you the wrong link. Everything's fine. We're ready to go. We're really excited to have you here tonight. I know you're very busy. We're honored to everyone. Please welcome our North Carolina Supreme Court Senior Justice, Anita Earls. We are so honored to have her here tonight, and we want to welcome you, Justice Earls. And before we start, I think maybe the best thing to do is let you tell everybody a little bit about yourself. I have some overview here, but I'd like for you to tell everybody a little bit about your educational involvement over the years with education law and with something about your legal career. Introduce yourself.
Sure. Well, thank you, Yvonne, so much for having me join the first part of the program. I'm really honored to be here. My background, as you see on the slide, a civil rights attorney in a variety of settings. I started out in Charlotte at Ferguson Stein Law Firm. And so there, amongst other types of civil rights cases, including obviously voting rights cases, I also participated in some of the litigation that firm was engaged in um, to essentially defend the desegregation decrees that Julius Chambers had obtained across the state, dealing with the desegregation of public schools. And then the other time that I did the most education related law would be the 2.5 years that I was at the US Department of Justice Civil Rights Division, because the education section was one of the sections that I had responsibility for. I was a political appointee in the Clinton administration. And in that capacity, got to work a lot with the Department of Education and the ways in which the federal government sought to enforce civil rights guarantees in education, but also saw kind of nationally how the overlap between school funding litigation, desegregation litigation, and kind of what education advocates were trying to do around the country. Since that time, I would say I had some work at the UNC Center for Civil Rights when it existed at UNC Law School. So working with Professor Jack Boger, who was director of the center, working with Julius Chambers, again, on some of the education advocacy. And so I would say those are the main times in which I've had an opportunity to sort of intersect the work of there's other things I did at the Southern Coalition for Social Justice, but um, really the main useful thing, I guess I would say, is that for the time that I was an advocate, I had a variety of settings in which I was able to try to address these issues of both educational equity as well as school funding questions.
Well, a great background to help us address the issue of today. We've invited you here tonight to help us get an understanding of the history and the development of the Leandro case. So as you know, this case has been going on so long that we get a lot of questions at public schools first of like, what is Leandro? Y'all keep talking about Leandro. What is this case about? And why is it still a case that's not settled? And so, as everybody should know, I hope, is that this was a lawsuit that was filed in 1994 by 5 low-wealth school districts. Later, other districts in various groups joined the lawsuit. But Justice Earl, I'm going to let you take it from here, because can you explain how the Leandro claim and what that means in terms of legal requirements of the Constitution?
Sure. And here I want to be perfectly clear. I am only going to explain the status of the case. I am not commenting on any aspect of the case that's pending beyond sharing what's already public, which would be the decisions of our court that I have participated in,
Right.
including dissents that I have written relating to the case. So those are the two things I am going to, throughout this entire little piece that I'm here, the two things I want to do is just give you an update on the status of the case, and to the extent it's relevant, share anything that is public that I've written on the case. But I am not commenting beyond that. And so you have an excellent summary of the progress of the case. I think it is not uncommon, I would say, for school funding litigation to take a long time. I guess I don't know any other way to say it. But I also think this particular piece of litigation is I mean, I haven't done a study of all the school funding litigation around the country and where this one fits, but it has been being litigated for a long time. And I think there's a couple of explanations for that, but the short answer is that the first thing that the plaintiffs had to establish was that what does it mean when the Constitution and the state constitution, and understand the reason why this is a state constitutional claim is because the federal constitution does not. There's a case that was previously litigated where the U.S. Supreme Court basically said we're not going to address school funding. Is a case out of Texas where a school funding mechanism was alleged to violate the federal equal protection clause because low wealth students were not getting the same educational opportunities as students in more affluent school districts, and it was because of the school system funding being predicated on property taxes. And the U.S. Supreme Court said, we do not recognize that as a claim you can bring under the federal Constitution. And since that case, the federal court, it is just not something protected in the federal Constitution. So our rights, our students' rights to a public education are protected under our state constitution in pretty robust ways. And so this differs state to state, but North Carolina is, I would say, is fairly extraordinary, because not only is the right to a public education right up there in Article 1, in, as the state constitution goes through what all of our rights are as citizens of the state of North Carolina, the right to a public education is there. But there's also an entire article of the state constitution that is entitled Public Education, and basically mandates that a variety of funding mechanisms, but mandates that the state provide, and the exact language in the state constitution is a uniform system of public education. So that's why it's in state court. That's why it's a state constitutional issue. And so the first thing that advocates did was what the first issue, and I'm summarizing here, but the first issue in 1994 was, is there a substantive part to that guarantee of a public education? In other words, can you require the state to provide some level of public education, or is it enough that there just is a public school? And the Supreme Court said, for this guarantee to have any meaning, it's got to mean something. And that's where the phrase sound basic education was used by the court in 1994 to say, yes, there is it's not just you have a school. there is a substantive element to your right to a public education. And then so then the parties came back to the court. And so all of this was sort of, what does the law say? We're just worrying about what does the law say. What So that's, so 97 took from 94 to 97 to get to the notion that yes, there is a substantive component, there's a sound basic education. Then the question was, well, what does that mean? What is a sound basic education? So Leandro too, but more fully articulated. Here are the elements. Here's what a quote sound basic education really requires. Maybe the biggest period then, the 10 years, was this series of hearings and orders about how to get to a sound basic education in North Carolina. What was, in fact, the state providing it already? Were there ways in which the state was not? What does it take to get to a sound basic education? Now, as you know, there was a decision in 2013 about whether or not funding caps on pre-K education were denying a sound basic education, and ultimately that issue kind of went away because the legislature changed the law. But this was I think a sense the parties and Judge Manning had a sense that these factual questions is what level of educational opportunities is being provided by the state, and does it meet the constitutional standard? That's in some ways an intensely fact-based evaluation, and that's what trial courts do. Trial courts decide the facts. So that's getting us up to that point.
So Justice Earls, kind of take a step back here, and how did we go from 5 counties being in the lawsuit to now it became a statewide remedy was ordered? I mean, that's kind of what happened between Leandro 1 and Leandro 2. Is that correct? I mean, how did that transition? What was that big difference between, how did we move from 5 counties to every school system?
Well, so here I kind of want to refer people to the 20. We'll get to it later because it's 2022. But in 2022, the court, in its opinion, went through this history for pages and pages and explained how the claims evolved from what the original 5 counties were saying to the trial court allowing other parties to join the case, and the trial court is the body that was managing who is joining the case, what orders would he issue, who was he going to hear evidence from. That's all the things that a trial court normally would manage. And as the opinion in 2022 explains, the initially the when it very first started, the case was only about are low wealth counties getting a sound basic education, but other counties wanted to join the case to say, wait a minute, we think there are issues in our county as well. And the Supreme Court, as we say in 2022, the North Carolina Supreme Court allowed that progression, if you will, to other parties to join, and for the trial court to assess the adequacy of what's happening across the state and not just 5 counties.
Okay. And you know, before we switch to, you know, we jumped from 2015 to 2018 here, but I just wanted to make sure the audience got the fact that Judge Manning, who had worked on this case for, you know, years and years and years, and had demanded that the state start fixing the problems, that actually in North Carolina Department of Public Instruction actually had a turnaround team, and were actually putting programs into some of these school districts and making some progress. And of course, then Judge Manning retired, and Judge Lee, as we see here now, took over the case in 2018. So can you tell us a little bit about what happened once Judge Lee took over? I mean, Judge Manning had said, I want you to fix these problems. And then Judge Lee said, what are y'all doing? You're not doing enough, best I can tell.
Well, again, like I want to refer everyone, I know, but to the 2022 decision, because that's not just me explaining the history, that is what a majority of the court says the history is, and the majority of the court recounting what the trial court did based on the record in the case. And the the Chief Justice reassigned the case to Judge Lee, and then the parties made motions about what should happen, and the trial court. Part of the issue is that the facts just keep changing, because over time what's happening in the state is changing, and so the court needed to enlist, right, experts who would assess statewide where are there deficiencies, if so where they are, and how might they be corrected, which is not uncommon in civil rights litigation, that special masters or independent experts are appointed to assist the trial court in determining the facts.
Okay, so so that's kind of how I guess Judge Lee appointed Wested as an independent research group to submit recommendations, as you see here in our little chart, to move the ball forward. That we need to have an independent voice come in and say, here are the things that could be done to make these problems, remedy these problems. Low performance in reading, low math scores, low attendance. There was a variety of stuff in this report. And I do want to say to all of our guests tonight that some of these things that Justice Earls referring to, when we send you a thank you for attending email, we're going to have all these sources and all these orders in the resource, so you'll be able to go and look at some of these yourself. And I think that will, as Justice Earl says, I think that'll give you some good understanding. And we have a wonderful timeline that's more detailed than this that we will also include. But the real heat, I guess, started when the judge ordered the transfer of funds in 2021. Can you talk a little bit about that and what impact that had on the case to this point?
So again, based on the history that's recounted in the court opinion, the Wested made their recommendations to the court. The parties had the opportunity, both sides had the opportunity to comment on them, and then it was up to the judge to decide again what the facts are, and that's when he concluded that in order to bring North Carolina's public education system up to that level of providing a sound basic education, those were there was Wested had recommended a plan, and the other, I think the other significant thing to understand is that to some degree there was at varying times consent to take some of these steps, and at other, and sort of a challenge about who speaks for the state, but the court ordered in 2021 that those funds be spent, and parties that had not participated up until that point then intervened to say, wait a minute, we now want to be heard on this, and we don't think that the court has the power to order those funds. And then that's what led to the 2022 decision. And I'm putting this link in the chat for you to share ultimately with everyone. But what I want people to know is that the oral arguments, both from 2022 and then more recently in 2024, those are now on YouTube. So you can watch the arguments of both sides. So in addition to reading the opinions you can watch the arguments and hear what both sides were saying.
Okay, so let's jump to the next slide. And now here we are in the last couple of years. After Leandro 4, which the Supreme Court confirmed that these funds were due and that the Judge Lee's order should stand. So maybe talk to us a little bit about at this time what happened and where we are today.
Right. So in January of 2023, the personnel. So remember, in 2022, the court had ordered that funds be spent. We did remand to the trial court to calculate exactly the right amount, because again, the facts keep changing because things keep happening, and the legislature had appropriated some money, but not all the money. And so the trial court, which is the place that decides the facts, had to decide exactly, had to take into account, well, what has the legislature funded and what more additional funds are needed. And so we remanded, we said, yes, these funds need to be spent. We remanded for that calculation of exactly what that figure should be. And that's what the trial court was underway in doing. But then after the election in 2022, the legislative defendants came back to the court and said, we want you to revisit this. And in January of I think I read that it was January 2023, the Court of Appeals essentially was in the context of a proceeding seeking a writ of prohibition, fancy language, but the Court of Appeals issued an order putting a halt to the payment of those funds. And then our court in March of 2023 essentially affirmed that. And I really wanted to take a moment to share with you this is the shortest of any Leandro opinion that you can find, that's out there. It's only a few pages, but the majority said, yes, that's correct. We are going to stop the payment. And I did write a dissent that Justice Morgan joined. And in that dissent, I said, I dissent from the court's extraordinary, unprincipled, and unprecedented action allowing the controller's motion in this matter. Today's order abandons the concepts of respect for precedent, law of the case, stare decisis, and the rule of law, all in the name of preventing the state from complying with its constitutional duty to provide a sound basic education to the children of this state. I then go through in my dissent all of the issues that the parties parties contended, the controller contended, were necessary for our court to resolve, and point to where we had already resolved those issues. And I conclude by saying that allowing this motion strikes another nail in the coffin for the rule of law. Our legal system is based on the premise that this court's orders and opinions will be treated as final and binding interpretations of North Carolina law and its constitution. The law of the case has long been a tenet of our jurisprudence. And then skipping just to finish, if I may. Unfortunately, we have waited much too long to see whether the state will abide by its constitutional mandate to provide our children, including at-risk children, struggling in under-resourced schools, with a basic, sound education. Thus far, at least 28 classes of students have already passed through our state's school system without benefit of relief. Not only is it true that justice delayed is justice denied, but denying adequate educational opportunities entails enormous losses, both in dollars and in human potential, to the state and its citizens. If our court cannot or will not enforce state constitutional rights, those rights do not exist. The Constitution is not worth the paper it is written on, and our oath as judicial officers to uphold the Constitution is a meaningless charade. For those reasons, I dissent. So that is what I said in 2022. In 2023. In 2024, we heard oral arguments, but we have not ruled. So that is the current status. The Supreme Court has not ruled on the issues that were argued in 2024, but you can go on YouTube and watch those arguments.
I think that's an excellent suggestion for those folks who want to um, hear that. And just a clarification question for me, in the previous slide, when the what was the basis for rehearing the case in February 2024? What was the basis for that?
So I do go through that in my dissent to the
Okay.
court's order, but basically, there are arguments that the controller wished to raise, which I say in my dissent were already resolved, about whether or not the state has the power to order that these funds be spent. And there's controversy over what the prior orders actually established. Um, and I think the best way, the oral arguments also focused, or I will say, in the oral arguments in 2024, there were also questions about whether or not school districts had standing to assert claims about whether or not students were receiving a sound basic education. And in my dissent, I say that that issue was resolved much earlier in the case when the Supreme Court in Leandro 2 said that the yes, basically it said yes,
Mhm.
that is permissible. So we there are, I think the best way to, again, like the best way to know what is currently in controversy is to see what was argued at I mean, the briefs are also public, but I'm not going to urge people to go and read hundreds of pages of briefs
Right.
necessarily. You can just take an hour and watch the YouTube.
Watch the video.
Yeah.
Okay. And so if you have a question, you can put it in you can look at the bottom of your screen. You should see a little Q&A, a little question box. Please put your question in there. And if you can't really figure that out, you're certainly welcome to put it in chat. I think we can see that too. We do have one question that was sent in to us, and I put that in the chat. If you can see that, Justice Earl, it was a very long question, but I thought a very interesting one. Maybe you can paraphrase that because you know what he's asking little bit better than I. But I thought this was a really interesting question.
So I think I don't see it in the chat here, but I think you're asking
Okay,
referring.
I'll try it again. Do you see it now?
No, but I think I know what you're referring to. You're referring to the question about where does the phrase sound-based education come from?
Yes, yes.
And the answer is, the short answer is
Mhm.
that in Leandro 1, when the court was trying to decide, does our constitutional guarantee of a uniform system of public education have any substantive component, that was the phrase that the court used in explaining, yes, it does. There is a substantive component. And okay, thank you. I do see it now. And I will say that I did not go back and look at the briefs to see if the parties argued that, but I do think that language was used in a lot of different places. But the notion that it's somehow it's an expansion, from my reading, and ask two lawyers what a court opinion means and you'll get four answers. But my understanding of what the Leandro 1 was doing there was not creating a new right or inferring a right from other rights. It was saying the state constitution says you have a right to a public education system. What does that mean? So it was, and that is the essential judicial function, interpreting constitutional provisions. What do they mean? And so the phrase sound basic education was how the court articulated what the right means. I'll also just say, so I do see this question, when do I expect a ruling? Will it be final? I don't, I cannot, I do not know. I cannot say for either parts of that question. Does race play a factor in the history of Leandro? I think that I can say my understanding is that at times there may have been some race-based claims brought by some parties that were then no longer a part of the case. So I cannot categorically say that race-based claims were never part of, have never been, or were never part of the Leandro case. But I will say that the as it's currently being litigated, again, the arguments that are before the court currently, there were not, so by race-based claims, I would say, interpret that to mean equal protection claims. Are Black students being treated differently than white students? And I do not believe there are equal protection claims of that nature currently in the case. And then, so why was the controller allowed to file an appeal in 2023? Again, all I can do there is refer you to the March 3rd, 2023 order. This is online. And I'll just, for people who do want to, look up these decisions, you should know that the official reporter title is Hoke County Board of Education versus state. So the name Leandro isn't currently in the official title fully. So the in the March 2023 order, that's where you can trace what the majority says about why the controller could be heard on these issues, and what the dissent says about why the controller should not be heard on these issues.
Okay.
So I do want to respond. So this question, so there's been excellent dialogue about whether race has ever been a factor. And the reason why I say that, I agree that it was not alleged in the original Leandro filing, but I believe that there were interveners from Charlotte Mecklenburg at one point in time who did seek to raise race-based claims, and then that was severed from the lawsuit and no longer a part of the case. So that's why I was hedging on whether race has ever been any part of the case.
And that's a very interesting point. Rodney Pierce, I think Rodney went to one of the schools that was actually in the lawsuit. And maybe we could give Rodney a chance to have a second to address this, since he was he's been lifelong involved in this case. But, I think it's important what he says there. If I hope everybody can see that, Hope County was chosen because of its 1/3 white, 1/3 Black, and 1/3 Native. Rodney, are you there? Would you like to make a comment? I'm letting you do
So I'm actually, Yvonne, what I really want to do here, just to be 1,000% careful and absolutely clear that I'm not
right.
I'm not engaged in any discussion around advocacy. I think I've said all I could. I appreciate the opportunity to share with you what I said in my dissent, and I appreciate the opportunity to go through the history, but I think it might make best sense for me to drop off at this point, if that's okay.
Yes. And I think the only other question that I saw was it Rebecca who asked if we were, why isn't there a time limit to when people can make appeals or have to give statements, or is that just not really true? I mean, can the timelines be set by the court and that's it?
Well, what I can say is that in the 200 plus year history of the North Carolina Supreme Court, I cannot find another case where the court has agreed to rehear issues. So in other words, the only appeal of anything our court decides is to the US Supreme Court. And the only time you get to appeal to the US Supreme Court is if our court is making a ruling about the US Constitution. So suppose our court ruled that, I don't know, your Fourth Amendment rights were violated under the US Constitution. You could appeal that and say, US Supreme Court, the North Carolina Supreme Court got it completely wrong about what the federal Fourth Amendment stands for. But there's no other appeal. We're the highest court in the land for North Carolina, for the state. There is a mechanism to request rehearing, and there is a deadline for filing petitions for rehearing. But there's also a principle that we don't change the law in a case, and particularly we don't change the law just because the personnel on the court have changed, because once we make a decision, we are the highest court. That is a final decision. That's why that is what I say in my dissent to our decision to rehear these issues. That is why I say this is a rejection of the concepts of law of the case and stare decisis and the rule of law. So that's my answer to that question.
Okay. And I do think I read someplace, last question for Justice Earls, or last one from me, and I'm going to move us on to the next part of our program. But Justice Earl, and when you look back to all the cases that were ruled on in 2020 or heard by the court in 2020, since, let's say February 2022, are all these other cases resolved at this point or have a ruling? Is this the only open case from 2022 before the Supreme Court?
I can say that the court files and the records will reflect that. So this case was last argued in February of 2024, and there are no other cases still pending from that date.
Okay, 2024. Okay, I had the year wrong. I'm sorry. Thanks for
No, that's
correcting me. So that's a precedent in itself. Well, Justice Earl, I think you've done a great job of answering the questions. You've given us some good resources to go and look. And as I want to remind everybody, I will be including these in our follow-up email to everybody. These links that she has provided, as well as many other fact sheets that we have and other copies of official court documents and rulings, so you can read this for yourself. And we do believe it's important to understand this case because it is so important to North Carolina, but it's also been one that's garners a lot of interest in that it's such a long-standing case that has been not been resolved. But thank you for
your
participation. And on the next slide, I want to just remind everybody that we are going to be, that Justice Earl is leaving. She's gone. She's no longer a part of our presentation for the rest of the evening, but we want you to stay around because we have some important information that we want to share with you. And our next presenter is Lynn Edmonds. Lynn is our Director of Outreach and Engagement. And we want to share with you some of the things that we are doing and other partners we have around the state are doing to advocate that we do resolve this case. And so, Lynn, I'm going to let you take it over. And for several people, Rodney will let you make some comments later. But, as we move through the end of this program, we'll try to see if there's a little bit of time left for any of you to share about some of your interests or questions or suggestions for the group. But Lynn, I'll let you get going.
I would like to hear from Rodney when my part is not very long, because he has been directly, affected and involved, and I think it'd be great to hear from him. But for our audience, we just wanted you to be aware that many of us, Public Schools First NC, and we know many of you want to advocate for the Leandro funding that our public schools deserve. So I just want to give you some tools and resources that you can use to advocate for the Leandro funding. There's 3 organizations largely that focus on Leandro, and that is Community Conversations. They have a project called I Am Leandro, Every Child NC, and then Public Schools First NC. So one thing I'd like to show you with Community Conversations, they've got a website, and on the top right, and we will send you the link to the website, but there is a Leandro tab, and you can select that to find petitions, and they have a postcard project to encourage lawmakers to uphold or follow through on the Leandro decision and provide those funds. And we wanted to spotlight for you tonight a resolution that they have. So this is just a screenshot of the resolution, but you can go to their website and sign it. And this can be signed by your book club, your civic organization, your church, any group or person can sign on to this resolution. The folks over at I Am Leandro, they have shared this resolution with every school board in the state and every board of commissioners in the state. So another thing you can do is to reach out to your school board or your county commissioners to see if they have in fact adopted this resolution. And if they have not, you could certainly encourage them and advocate for them to do so. Again, we'll send you the link so that you can get to that resolution yourself, but the folks over at Community Conversations are working really hard to get this resolution passed by as many folks in North Carolina as possible. And it's free and it's easy to do. So we encourage you to check that out. Every Child NC has a really excellent tool that they put together in 2022. And the reason I do want to say to you that you can actually go to their website and find what the Leandro funding would do for your specific county. It's an excellent tool. It's easy to use. And you can find it under their resources tab on their website. Again, this is just a screenshot. Now, when you see those 2022 numbers, they haven't changed drastically. So don't get bogged down in, well, what does it mean for 2025? The bottom line is the same. Our public school children across North Carolina will benefit from these funds. It means more educators. It means more pre-K. It means more, counselors, school psychologists, social workers, et cetera. It means more funding for classrooms, period. So the 22 numbers, are good enough, and we go with that. And we really appreciate this tool from Every Child NC. It's something that we at Public Schools First have referenced many, many times. And I'm going to show you how we've referenced their great work in just a second. So over on our website, we've got fact sheets about Leandro. We have some social media content that I'm excited to share with you. And we don't think at Public Schools First NC that you can talk about Leandro funding without also talking about the hundreds of millions of dollars that are now being poured into vouchers. So we believe that voucher data and reports are directly tied and relevant to Leandro funding. You can find all that on our website. So one thing specific is we do have a more detailed Leandro timeline in our fact sheet. And we're, again, going to send you these links in the follow-up email. And we've done Leandro webinars before. So we've had some of the attorneys that have actually worked on the case have been our guests on a couple of webinars that we've done in previous years. And you can find all of those on our YouTube channel. And we hope that you'll check those out. So here's some of the social media content that I wanted to share with you. And the one on the left, it does reference that work by Every Child NC. This is really impactful for you to share on your own social media platforms. It's formatted that these will fit on Instagram, which has more of a square, formatting. They'll fit on X, they'll fit, on Facebook. But these really help your your network, the people in your community, your friends, your family that are following you on whatever social media platform you're on understand how Leandro would impact your individual county. And we took the data from Every Child in C and we plugged it in here with some other statistics and some other data points. And we have these for every county in the state. I'm showing you Wake County as an example, but we do have these for other counties. You can find them on our website under the county profile data, but you can grab the one for your county and start sharing that on social media and tag your school district, tag your board members, your school board members, tag your local county commissioners and your state representatives, tag your House member, your Senate member, because these numbers matter for our kids. And it's a really great way to raise more awareness because not enough people understand the impact of what it would mean to get these funds. And then on the right side, you'll see, again, this is another social media tool. This is an example of Chatham County. This is specifically about vouchers, about how much money each county is losing because of the voucher expansion and the hundreds of millions of dollars going into private school vouchers, and how it hurts Chatham County in this example. But again, just like the image on the left, we have the image on the right. Again, Chatham County is the example here, but we have these for every county in the state. And as you share these on social media, it really helps communicate the gravity of the situation, and helps in our advocacy work to show people these numbers that are personal to them in their own home county. This is some of the voucher data that we wanted to share, just a couple of slides. This shows you where most of the voucher funds are going per county. You can see that our most urban populated counties are raking in hundreds of millions of money for voucher schools. And you can see that in other more rural parts of the state, they may have very few voucher schools and they're not getting as much voucher money. But regardless, it hurts every North Carolina student. It hurts every North Carolina school district. And we need the public to understand how obscene this voucher funding is. So this is just it's like a heat map, if you will, of where the voucher dollars are going. This is, we refer to this a lot. So when vouchers started in North Carolina, they were sold to the public as a way for children to escape their failing public schools. And they were marketed or sold to the public as a way to help mostly Black and brown children that, didn't have a lot of resources. And we needed to give them a tool to help them escape their failing public school. Well, you see with the expansion over time, how the demographics have flipped. These voucher dollars are mostly going to white families for their private school tuition, most of which were already in public school, already paying the tuition on their own, didn't need a coupon from the state, from your tax dollars, but that's what's happened over time. And we find this very alarming. And again, it'd be great for you to share this on social media as well. We have whole programs and webinars about vouchers, so we'll stop there. But you can't talk about the need for Leandro funding without reminding the public that there's plenty of money to go around for private school vouchers. We need to be funding that Leandro plan. An upcoming event, we have our next webinar is next week. We're going to be working with the North Carolina PTA to host North Carolina Superintendent Mo Green. He's going to talk to us about his new strategic plan. So we're excited about that. And there's a big conference coming up October 3rd and 4th at the McKimmon Center here in Raleigh. I believe there is a fee to attend this conference, but it's really good. We've been for many years, I think every year that they've ever had it. And this is from our friends over at the Dudley Flood Center, which is part of the Public School Forum. So their Color of Education Conference is coming up October 3rd and 4th. You can find information at their website about that. And we will be there tabling, so we will see you there. And then the North Carolina PTA is having their statewide convention the following weekend, October 10th through the 12th. That's also at the McKimmon Center here in Raleigh. And again, as I said just a moment ago, we do whole programs just about vouchers and the voucher expansion and take a deep dive into that. We do advocacy trainings. We can do a whole presentation for your civic group or your PTA, what have you. And these are all free, and we do film screenings, and these programs can be in person or virtual. It depends. We don't travel too far, but in some cases we can do them in person, but we can offer any of them virtually, and they are free to you. And since I mentioned PTA, let me say this quickly. Back on the resolutions page from our friends at Community Conversations, let me just scroll back to that. Here, PTAs can sign this resolution in support of the Leandro funding. Do not let any PTA leader tell you that you cannot do this. You absolutely can. PTAs are 501c3s, and so therefore, like us, they can't endorse candidates or, tell you who to vote for or endorse a political party or a candidate at any level. But PTAs are allowed to take positions on issues, and this is a perfect example. And PTAs are allowed to pass resolutions. So take this to your PTAs and use it that way. And if you run into any obstacle or what's the word I'm looking for, objection, get in touch with the North Carolina PTA, and they will help you, because it's absolutely permissible, and we encourage you to do that. So I'm going to go to our contact slide. Forgive me for flying through these. And Yvonne, if it's okay with you, I'd love for Rodney to make his remarks.
Yeah, feel free. And everyone, if you have comments or questions you want to have to us or so forth, unmute yourself. I've asked our technical person to unmute you. You can raise your hand, and we've got some extra time because we got through everything so fast. So Rodney, if you want to share a few of your comments, and we can because you actually were involved personally in this case. So tell us a little bit about your perspective.
Yes, ma'am. Thank you, Yvonne. Thank you, Land, for having this webinar tonight about such an important part of North Carolina's educational and legal history. I reside in Halifax County, and I'm an alumnus of Halifax County Schools. When Leandro was initially filed in 1994, I was a sophomore in high school in Halifax County Schools, and that case was filed in Halifax County Superior Court. The first judge to hear Leandro was the Honorable Richard Alsbrook, who has since retired, of course. He was the son of the Honorable Julian Alsbrook, who was a longtime state senator. We actually have a highway in Halifax County named for Julian Alsbrook. But being a quote unquote Leandro kid, one of the things I wanted to do once I became an educator, I taught middle school social studies for 9 years. I wanted to learn more about the case. So one of the gentlemen that I talked to was Mr. Larry Armstrong, who is the board attorney for Halifax County Schools, was the board attorney when the case was originally filed in 1994. And when I asked Mr. Armstrong, well, why wasn't, if the case was filed in Halifax County Superior Court, why didn't they use a family from Halifax County as the namesake of the lawsuit? Robert Leandro was from Hope County School, was a student in Hope County Schools. And he said, well, one of the reasons that we used him and used Hope County was because at that time, the student population, or the population in general, in Hope County Schools was a third white, a third Black, a third Native. So nobody could try to say, well, this is a quote unquote predominantly Black lawsuit or predominantly white lawsuit. It was a interracial lawsuit, through a third of each, race or ethnic group. He also said that Robert Leandro was used as the namesake or the lead plaintiff on that lawsuit because his name is extraordinary. He said, if I say it's Williams versus State or Brown versus State or Johnson versus State, you're going to be like, okay. But he said, if I say Leandro, you're going to say, oh, that's an extraordinary name. It might make you open your eyes or sit up a little bit, like, well, who's that? And that's one of those are the reasons that Hope County was used as a plaintiff, and Robert Leandro being from that area, his name was used for the lawsuit. He also told me that the money, this is going to what Lynn was saying about vouchers. He also told me that the money that has been spent, I don't know if he meant money spent or money appropriated on vouchers, could have paid for the Leandro plan by now. I don't know how accurate that is, but that is something he shared with me as well. So just wanted to share those things. And I was trying to answer the question that had been posed to Justice Earls earlier about was race a factor? And I was trying to say, initially race was used in the premise of, hey, we're going to make sure that this is equally balanced, so nobody tries to, say race was used as a factor in the lawsuit, because according to Mr. Armstrong, this was about low wealth counties, as Justice Earls said, suing because they could not make up the shortfall in funding that they were not receiving from the state. These are the words of Mr. Armstrong.
I think that is really helpful and
Hmm.
very interesting. So thank you for sharing that. I was not aware of that. So thank you.
And Rebecca, are you still on? You've done a tremendous amount of work on Leandro. I wonder if you wanted to share a few comments. If someone could unmute Rebecca. And feel free to share some of the work that you're doing in Wilmington.
Thank you so much, and thank you for this opportunity. I think this conversation has been impactful, tremendous, and I have learned things, and I have been studying Leandro versus North Carolina intensely since 2024, when we launched the I Am Leandro campaign. The reason why we launched the I Am Leandro campaign was because I felt like more people needed to see themselves as stakeholders in public education, personally. And I'm a woman with no children. I'm not a teacher, but what I understand is that we are all stakeholders in public education, and these kids are our kids. And it's our responsibility as a society to do our part to make sure that our children are prepared to enter the workforce or whatever life has for them next. And when I see that we're not meeting the bare minimum of what the Constitution requires of us, it requires all of us to take action. And so we have a number of ways that you can take action. And I do want to make a point of clarification about the resolutions. That form that you see on our website, it will take you to a place to download a template where you can customize the resolution. If you want to, if your organization is interested in endorsing these resolutions, passing these resolutions, I would ask you to please do it and email us and let us know so that we can celebrate you. And our email address is also on the email on the website. And there's a long one, and there's also iamleandro.org. So please, if there's anything I can do to support the work of other people, we're here to help. And yeah, sign the petition, share it, pass resolutions, read them. You'll learn a lot. I know I did in the process of working on those, and we can do this. I think that's the one thing I also want to say is that a lot of people have worked so hard for so long. It's understandable that people are tired. This is the one thing I know is that the law is on our side and we have each other and we cannot fail. So thank you all.
Well, Rebecca, thank you, and all the work you're doing with I am Leandro. It's been a joy to partner with you, and I'm really proud of it. And thank you, Rodney, for never giving up on this case and continuing to bring it to the light of day. Rodney, just share with everybody, how old are you now?
Why are you gonna do that to me?
Come on, buddy. That's a bad thing to do. But I want to say that this is a grown man telling you that he was a Leandro kid.
Yes,
And
yes.
here we are,
I
all these
was. Let me
31
see.
years later,
Yes, ma'am. I will be 47 in October.
and
So,
proud of it, right?
yes, ma'am.
Think
Yes.
about that. This young man and generations and after generations after cohorts of children have not been able to benefit from what the court said they were legally obligated to have. The resources they were obligated to have by the North Carolina Constitution. And that's really mind-boggling. I want to leave you with that thought about, think about the cohorts of kids. 28 cohorts of kids have gone through school, finished school, without having the benefit of this case. And as Lynn pointed out, that's very maddening when you think about the millions and millions we are pouring into private school vouchers right now. And while we're neglecting our kids and our public educators is really a shame. So thank you for joining us tonight. Thank you, Lynn. Thank you, Rebecca and Rodney. I want to also mention Heather Coombs is with us tonight. She's our communication and research director. So a lot of these great resources you see come from Heather, and a lot of our wonderful assets on social media and our website come from Elizabeth, who's also with us tonight. So we're a small but mighty team. We need all the help we can get. So you guys join with us, and let's see how we can make sure that we live up to the Constitution of North Carolina and we provide every child with a free, high quality public education. We appreciate you. Good night, and we hope to see you next week when we interview Superintendent Mo Green. Good night, everybody.